everyone, welcome to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. The scope of maritime law. The foundation of maritime law is a significant body of well-established common law developed from ancient practices of maritime commerce and from the decision of maritime courts applying those standards of traditional admiralty law. In what has become known in the United States courts as the General Maritime Law. Maritime law also includes statutory enactments, many of which are driven by, or at least based upon, international conventions and agreements, as well as established maritime customs. In some ways, maritime law has developed apart from and somewhat in tension with local civil laws. It has done so because the fundamental purpose of maritime law is different from that of the civil law. While the civil law developed to help maintain a civil society and resolve disputes between members of a single nation, maritime law developed to promote the just and speedy resolution of disputes among persons from possibly different countries involved in maritime commerce. In Restoration England, the admiralty courts often battled the civil courts for reasons more related to access to court fees and jurisdictional power than legal policy and jurisprudence. In the United States, the tension between admiralty courts and local courts has been more affected by the tension inherent in our federal form of government. The designation of matter as an admiralty matters brings it within federal jurisdiction and makes it subject to federal maritime law. The necessary consequence is that the state law that would otherwise apply is supplanted by the federal rule of decision. To balance the national interest in a uniform maritime law with the local state interest in preserving state jurisdiction over local matters, the Federal Judiciary Acts have noted that the federal courts have original jurisdiction, exclusive of the courts of the states, over any civil case of admiralty or maritime jurisdiction, but then goes on saving to suitors in all cases all other remedies to which they are otherwise entitled, or this is referred to as the savings to suitors clause. Under that formulation, maritime cases are federal cases subject to federal maritime law and within the jurisdiction of the federal courts. However, those maritime cases that present issues traditionally within state common law jurisdiction, in other words, contract and tort cases, can still be tried in state courts. Despite that compromise, the scope of maritime law remains in tension with the scope of state and other federal laws. Maritime laws continues to adapt to changing commercial practices and demands, such as those posed by intermodal shipping, mixed sale, purchase and delivery contracts, amphibious vehicles, and changing financial, social and employment standards. However, the traditional rule of thumb remains generally true matters that involve vessels or the movement of goods or people by water will likely involve some aspect of maritime law. This chapter further outlines the reach and scope of maritime law. Maritime law is a body of a law applicable to maritime commerce and vessel. The key to understanding maritime law is to understand that it has developed to promote maritime commerce, which is a matter of international concern and practice. As a consequence, while most maritime nations have their own maritime law, the principles of maritime law are mostly consistent among maritime nations, and decisions based on general maritime law principles are widely recognized around the world. Admiralty law is generally synonymous with maritime law, although admiralty law is more correctly understood as a subset of maritime law. Admiralty law evolved as an amalgam of international common law and civil law or codes decided by judges who would look to international practices and custom as well as to the local civil law to determine what standard to apply to maritime disputes. Maritime law in Maritime law includes not only admiralty law or maritime common law, but also maritime statutes and regulations enacted on a nation by nation, basis or based on international conventions. Over time, nations have tended to enact specific statutes to codify traditional admiralty law concepts such as maritime lines and cargo claims, or to address other maritime matters that were not traditionally viewed as admiralty issues such as vessel mortgage and marine insurance. More recently, most nations have implemented specific statutes regarding vessel construction standard, pollution prevention regulation, seafarer protection regulation, and similar laws. Much of the international maritime law is now based on international conventions developed under the auspices of the United Nations International Maritime Organization or IMO. Much of United States and international maritime law developed from English admiralty law as first applied by local English maritime courts and then the English High Court of Admiralty, a special court under the authority of the Lord High Admiral formed to deal with maritime specific issues in 1339. Local English courts developed procedures over time that were intended to promote maritime trade. Then, as now, merchants depend upon the ability to keep their vessel moving and to minimize the amount of time that vessel might be detained in port. They naturally prefer trading to port when they could be assured of prompt resolution of disputes where they would not be exposed to arbitrary local influence from a hometown jury and where the rules of decision would be as close as possible to those used in other ports. These courts tend to have trial by experienced maritime judges rather than local lay jurists who might not understand the exigencies of navigation or maritime commerce or who might be more subject to local influence. Expedited trials and other procedures for resolving maritime disputes, more flexible standard for evidence and taking or preserving testimony, reference to established sea codes or other international standards, procedures for obtaining security for claims by arresting vessel or attacking vessel, and procedure for interim relief for stranded sailors. Ultimately, the local maritime courts were centralized by the English royal government and placed under the authority of the Lord High Admiral. That eventually led to tension between the Admiralty courts and the common law courts over jurisdiction and the benefit of fees from the handling of disputes. By the time of the American Revolution, the two court systems had reached a point of equilibrium, with the Admiralty courts claiming jurisdiction over matters arising on tide waters and the high seas, and the local courts assuming jurisdiction over all other disputes. The Federal Admiralty jurisdiction was implemented through the Judiciary Acts of 1789 and subsequent versions now codified in the United States Code. The statute setting out the jurisdiction of federal district courts over maritime cases states, Admiralty, maritime and price cases, the district court shall have original jurisdiction exclusive of the courts of the states of any civil case of admiralty or maritime jurisdiction, saving to suitors in all cases all other remedies to which they are otherwise entitled. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.